elected authority, you call it as a republic, and that is democratically elected, and therefore the President of India is elected by elected members of state legislative assemblies within parliament, right, through the system of proportional representation by means of single transfer vote, so that popularly elected president will be there. So the only clue that we have is from the phrase democratic republic. And therefore, the supportive documents are supportive articles like 53, 72 and all others, right? All the contracts shall be made in the name of the president, right? Article 299, right? And then Article 361, no action can be taken against the president or the governor for the performance of his power or discharge of his duties, nothing can be done, right? So all these articles put together, we may safely conclude that the president is the head of the state. The answer is not complete. But when you go to the second question, right, possibly we may try to find an answer even for the first one. Right? Okay, what is the second question? I am running a little faster because I wanted, this session is for the question paper session. Right? What is the head of? Please check your mobile phone. Oh, answer bigger. What's the formula? Michael, you are ready. You know the answer, that's what you are saying. Right? You have said the Prime Minister, ChatGPT cannot be anything else. Right? Now my question again. Prime Minister. Oh, now we did it. Okay? Now the question comes into picture. Where is the legal basis? What is the legal basis? I think ChatGPT also says that, isn't it? No, it says. It gives. It refers to an article, isn't it? Huh? No, 74? Right? So it makes a mention about 74, 75, 1, 75, 3, right? I think Hindi mein can also usko bypass hai. Right? That is not the answer. Right? Please check the first article that we refer to, article 74. And आप पढ़ लीजिए, मैं तो कई बार पढ़ चुका हूँ. Right? The Council of Ministers. The Council of Ministers at the head of the Council of Ministers. Right? To aid and advise, let us not think. So Article 74 speaks about the Council of Ministers. Prime Minister is the head of the Council of Ministers. Government India. Right? He is not the head of the government. Why? The Constitution specifically, we are not reading the English Constitution where nothing is written. Right? Otherwise you have to refer to the law. Reading the text of the Constitution, otherwise they took 2 years, 11 months, 17 days to complete the drafting of the Constitution. They serve right? So what you have written, that is why it is the fundamental law of superior obligation. Fundamental law, superior obligation. Therefore, that should be the guideline, that should be the basis for our conclusion. So, Article 74 speaks only about the Prime Minister being head of the Council of Ministers. The subsidiary question arises, is Council of Ministers the government? You got the point? Is the Council of Ministers the government? The answer is no. It cannot be. Interestingly, I will come to that little later. You go to Article 75, Clause 1. What does it say?
The Prime Minister shall be appointed by President and other.
The Prime Minister shall be appointed by the President. And other ministers on the advice of the Prime Minister shall appoint. Does it say anything about the government? Then 75 clause 3, isn't it? Or 75 clause 2 also.
The minister shall hold office during the period of the president.
The ministers, please, I want you to carefully look at this. 75 clause 2, which is not given in ChatGPT, but I want you to read that carefully. It says, the minister shall be, what is that?
The minister shall hold office during
Shall hold office during the
pleasure of the president.
pleasure of the president. Right? Now, I don't know, I am a student of constitutional law for quite some 4 decades. Pleasure of president का मतलब अलग है. Without giving any answer, without giving any reason, चला जाएगा. Right? But in practice, it doesn't take place. Right? It doesn't take place. So therefore, our conclusion or understanding is, the theory, the text of the constitution says something else, but in practice we do something else. There are corrupt ministers in the council of ministers, right? The president does not remove them. Right? Why? I think the stupid Supreme Court has written a wonderful judgment in 1974. You know, these are the things that you need to understand. 1974, can you tell me who is the first Chief Justice of India who is appointed out of term? Justice A. Andre, very good, right?
Prime Minister Indira this time.
Indira at this time, A. Andre was appointed, superseding 3 of his senior colleagues, Hegde, Grover and Shelley, right? And all of them submitted the resignation and left. Right? Because they didn't want to work under the junior, right? Who was taking their command earlier, now they have to work under him. So they resigned and left. Now it was the same A. Andre who decided this case. So I am giving you the background, which the books will not give. Right? As a teacher, your job is to bring all this information to the knowledge of the students, allow them to decide. Right? So A. Andre, who was appointed out of turn, in 1973, he decides a case called as Samsher Singh versus State of Punjab. Now, what is it there in the case? The facts are very simple. They wanted to remove, the governor wanted to remove a judicial officer. That's all. Right? For that factor, 7-judge bench, right, went through all the documentation and they went out of context. It is not about the removal. Removal governor to kar sakta hai, right? The governor appoints all these people and they hold office during a pleasure. But if they are civil servants, there are civil service rules. Right? We follow them and remove them. Arbitrarily you cannot remove. Political appointees you can remove. For example, if the president feels that the governor in Tripura, right, I should not take his name, right? And should not be there. They will not say, my pleasure is withdrawn. No. They will appoint Vijayakumar will go as the governor of Tripura. So I will come here. Right? The moment I join here, it automatically goes back home. That is the meaning of pleasure. The president need not give any reason. Right? In Tamil Nadu, there was one governor, Prabhudas Patwari. Right? Gujarati. Right? So, it gives flavor. Right? And he was a true garbage. Right? When he went as the governor of Tamil Nadu, no liquor to be served in Rajbhavan. Right? Very strict rule. No liquor to be served in Rajbhavan. Number 2, I don't know how many of you have gone to Rajbhavan there in Chennai or what is it? Or we call it as Madras. Right? If you just get into the compound, the deers, there are more than 600 deers in the campus. They just come near you, smell you, touch you and go. But you cannot kill them because it is against the rules, right? So everyone will be tempted those non-vegetarians will be tempted to taste, you know. So Neelam Sanjeev Reddy, I have given you all this story because when you give lots of information, the critical thinking is ignited, right? So Neelam Sanjeev Reddy went for a foreign visit, came to Singapore. You know, now we have direct flights from Singapore to Delhi, right? So he came to Madras, and they can't stay in five-star hotels. Outside it's possible. When they come inside the territory of India, they stay only in Rajbhavans, right? So he went to Rajbhavan, and he used to drink. So I asked them, can you provide some liquor? They said, no, sir, there is a ban. Then he tolerated, then in the night he asked for dinner, can you give me some non-vegetarian food? He said, no, there is a ban. He gave ban. So next day he left for Delhi. In the evening, he applied this doctrine of pleasure, right? Appointed somebody else. And Prabhudas Putari knew everything, kept everything back. The moment the next governor came, he just went back to Ahmedabad. Right? No reason, no rhyme. Similarly, this is the one way. It is personal. Congress appointed Sheila Dikshit, the three-time Chief Minister of Delhi, as the governor of Kerala. 15 days, I think she was the governor. The election took place. BJP came to power. The same stupid president, I'm using the term, strong term, stupid president. If I were the president, I would possibly resign and go. 3 months only I have appointed, right? Why should I remove somebody just because of party politics? Right? Always the Indians submissive nation, right? The submissive nature of individuals. So, right? So, Patwari went, Sheila Dikshit, unceremoniously. They went to the court said, no, she holds office during the pleasure of the president. We can't get into pleasure. Right? Why the pleasure is wrong, we will not get into it. Right? And that is the nature of the power given under the Constitution. So therefore, in some places we justify the head of the state as the doctrine of pleasure, and in some places we don't. Right? So in Samsher Singh, 7-judge bench, unanimous bench, they totally amended the Constitution. In the removal of a district judge, or not even a additional district judge, right? They went wrong and finally they consolidated, right? See what they said. 7 men in black as judges read the Constitution also black. Their advice is, I am not joking, please read the judgment. Wherever, carefully listen to me, wherever you come across the term president is satisfied, it used to be understood as the Prime Minister being satisfied. No amendment, Constitution still remains the same, right? Now, you say, wherever you come across the term, President can't say either. It is about the governor and the chief minister. It is about removal of the judges, judicial officer, not in a high court judge, as, a subordinate judicial officer, removed by the governor, and president can't say, right? And then they say, second sentence, wherever you come across the term governor, you have to understand that as the chief minister. And in coming to that, like mathematics, they have deducted something which there is nothing in the Constitution, right? We have adopted parliamentary form of government. Where did we adopt? When did we adopt? No answer.
26.
No, we didn't adopt. We did adopt that India will be a parliamentary form of government till date, except this judgment. Right? So they said we have adopted parliamentary because there were discussions in the Constituent Assembly. See how beautifully they cheat, the judges. Right? They said we lived under the British regime for 300 years. We are comfortable with the British parliamentary system. which I think as a student of law, you should question. 300 years, no doubt we lived under British regime. It is not under British regime. 1600 to 1858 under the East India Company. Company is not government. From 1858 onwards, we had what you call it as the Governor General, not the Parliament. Governor General is one single authority, one individual, right? And therefore, 1919, it slowly introduced something called as Governor in Council, right? A small body to advise him. 1935 Act, they brought in the federal issues, fine. Where was the Parliament? Where was the legislature? All these acts till 1935. There was nothing. If somebody is saying we lived under British parliamentary system for 300 years, it is fooling the entire masses, right? And therefore we have accepted parliamentary form of government. After 2-3 paragraphs from parliamentary government, they said it is Council of Ministers form of government. I don't know what is meant by Council of Ministers. After 2-3 paragraphs, we have cabinet form of government. In the same judgment, cabinet form of government. 2-3 paragraphs, it is prime ministerial form of government. To remove an ordinary judge, where the prime minister comes. Right? Now we go back and read the judgment. You look at who was the Chief Justice of India, it was the same A. It was nothing but a thanksgiving judgment. I hope you understand what is meant by thanksgiving judgment. Right? You made me the Chief Justice of India, otherwise I would have become, the 3 people will become one after the other and I will retire before them. Obliged. You have obliged me, so I am giving. Right? And same thing was done in that another case, habeas corpus case. What is that? Area Jabalpur versus Shukla. One judge dissented. Right? H.R. Khanna. Right? What happened? When his term came to be appointed as the Chief Justice of India, they said, no, we will appoint M.H. Wade. Right? So you look at this, the head of the government is not mentioned anywhere, but the Supreme Court, by its opinion, very clearly amended the Constitution thoroughly. There are more than 150 articles which speak about the President or the Governor. In one judgment, they said wherever you come across the term President, read it as Prime Minister. Wherever you come across Governor, read it as Chief Minister. Right? So if you mention all these things, then you make the students little alert. Still the answer is not clear. Right? In the Constitution, there are many dictionaries. I am using many dictionaries. Why many dictionaries? Article 12, for example. Right? What does it say? The state. What does it say? The statement. State includes. It's an inclusive definition. The government and Parliament of India, the government and legislature of the states, right? Blah blah blah. It goes. It's a definition. It's a definition, right? Article 36 and 37, I think directive principles, they say the same definition of Article 12 will apply given to directive principles. That's also another definition. There, the government is not mentioned, the government is only used. Government and the Parliament, government and the legislature of the state. Now, what is this animal called as government then? Is this animal equal to Council of Ministers? The answer is no. If that was the case, they would have mentioned the state includes, right, the Council of Ministers and the Parliament. But they use the term government and the Parliament, government and the state legislature. Right? So, I am a little confused. We try to figure out. Then there is a larger dictionary in the Constitution. I don't know how many of you know this. Article 366. Right? Article 366. And if you read that Article 366, it says, unless the context otherwise required, the following phrases will have the assigned meaning, right? and then everything is alphabetically organized. I think 366 clause 2 speaks about Anglo-Indian. Right? Now you remember the amendment made by this present government. The reservation of 2 seats in Lok Sabha, if the Anglo-Indian community is not adequately represented, you see the definition in that. You will understand why it was that. Right? Otherwise you will not relate it. Anglo-Indian is defined in that. So when you go down, look at government, government is not defined. Government is not defined. So it becomes your more difficult. Right? And we stop. This also 366 also I am telling. The Supreme Court has not looked into, nor the 7 judges have said anything about it. Right? So the government is not defined. Where will I go? Immediately after 366, I think every one of you should know this. There is an article 367. Right? I want you to read at least the opening statement of 367.
Unless the context otherwise requires, the general clauses at 1597.
Unless the context otherwise requires, the General Clauses Act. Act of 1897. Who made it? British Parliament made it. Right? 1867. Yeah.
So subject to the any adaptation and modification that will be made under Article 372 applies for the interpretation of this constitution.
Of this constitution. See the beauty. An act passed by the British Parliament, including adaptations, right? Modifications made by the President under Article 372, will be used for the interpretation of this constitution, as well as there is something else also.
Applies to the interpretation of this constitution as it applies to the interpretation of an act of the legislature of the Dominion.
Right? Dominion of India shows this. Now Dominion is called Parliament or State Legislature. Any interpretation you would like to make, the General Clauses Act will apply. Right? So still the answer is not very clear. The question is, who is head of the government? We are trying to find where the government is. Right? 360 is, nothing is there. Government contract is there. Right? Every contract is to be made in the name of the President and the Governor. Everything is there. But government is not being defined. Now you come to 367. Please go to General Clauses Act. Alright? I think that is the beauty of using this electronic device, laptop, mobile phone, whatever it is. Section 3 is the definition clause. Usually section 2 is the definition clause in many of the statutes. In very few statutes, section 3 is the definition clause. I think one is this, the other one is Motor Vehicles Act. That also speaks in section 3. Can you just go to section 3, subsection 8. Right? In that, read the second paragraph. So the definition is about central government. And see the second paragraph.
Be in relation to anything done or to be done after the commencement of the constitution.
After the commencement of the constitution. This amendment was made through the Constitution 7th Amendment Act. Right? Now the central government would be after. Yeah, please read this.
In relation to the anything done or to be done after the commencement of the constitution, being the president and shall include.
Means the president. Forget about other things. Right? Central government means the president. You said he is the head of the state. But now the statute, which is the authority now, it says he is the government. He is not even the head of the government, he is the government. Can there anybody above him? Can the Prime Minister be above him? Right? So I tell the students, if you want to become a civil servant, right, your answer should be, the head of the government is Prime Minister. If you write anything else, you will fail. I hope you understand what I am saying. If you are serious, you want to become an IAS officer, right, you have to give the wrong information. to get qualified, not the right information. If you write one paragraph answer, no, according to Article 367, right with General Clauses Act, he is not head of the state, finished, right? And that is why IAS officers, one of my colleagues expands IAS as not as Indian Administrative Service, I agree service. Right? If you think any IAS officer, what the name in this country today, who would stand up and say the minister is wrong, the chief minister is wrong, or the prime minister is wrong? They may say, if by evening they will be the Mr. Kendra or no. So they will be either sent out, or next day there will be charges served against them, transferred. He may be the home secretary, by evening he will become a corporation secretary. And when you give all these facts and figures, ultimately you get to into the thinking process of the students. So you have a constitution, you go to all different provisions, go to the statute, go to the judicial decision, and give one or two examples like this that makes masala, right? That is also necessary for us to understand, right? And then you look at it. The last point I would like to mention is, when was this judgment delivered? Samshir Singh? 1973, right? Does 1973 indicate anything? That's a judgment of it. What is the political situation in the country? Huh? Yes, Indira Gandhi, right? There was an emergency declared during the Indo-Pak War, right? The war lasted for 14 days, 2nd or 3rd December to 17th December, right? War was over. I think if you go to this palace, there is, right? General Niazi arresting around 97 or 98,000 Pakistani soldiers, and with due respect, they were sent to Pakistan. Right. Emergency was planned on that day. It was not revoked after the war was over. It continued only to be replaced or substituted by a new emergency in 1975. Armed rebellion. Internal disturbances. Armed rebellion was inserted. Right? So, internal disturbance in 1975. So, the judgment was delivered during the emergency and under Article 352 of the Constitution. And she was a terrorist. She was a migrant. Right? And anyone from Bihar? Right? So, Uradu. Right? If somebody objects to anything, Uradu. One CBI inspector, very honest fellow, he had that scooter, Vespa scooter. He was investigating something which they didn't like. Right? One fine morning he was coming, a truck came and ran over him. Finished. I say, no, that we can disseminate evidences, eliminate people. She was a terror. That's why everyone obeyed her. When you bring all these facts and say, President is the government, and if he is the government, there can be nobody above the government. So the safest conclusion that we can arrive at is, the President of India is not only the head of the state, he is also the head of the government. Why? I will go to Article 75, Clause 2. Article 75, Clause 2. What does it say?
The ministers shall hold office to the King.
Pleasure of the President. The ministers also include Prime Minister. The judges also include Chief Justice. Right? So ministers also includes the Prime Minister, and therefore the Prime Minister also holds the office during the pressure. Whether they can be removed arbitrarily, these are issues which we will go through. I think we have gone a little away from all these things. So therefore, I am just in two small questions. I tell the students, if you want to take civil service or judicial service examination, you have to write the wrong answer to get qualified. But as a student of law, if you have to initiate your thought process, you have to bring your critical thinking, right? Then you have to investigate, you have to identify, let's go, what to get. As a student of law, I will rely upon the law, not even the judgment of the court. Judgment of the court is like weather, right? There are 4 seasons and 4 different judges will come and, right? If you give the same case to 2 different judges, they will decide in 2 different ways, right? So there is no uniformity. After 5 years, after 10 years, today the Supreme Court, left, right and center, they keep on saying we have separation of powers in the basic structure. For 23 years, they said there is no separation of powers, right? So you have to appropriately bring those judgments, right? And anchor them to constitutional provisions, and then raise this doubt. You don't have to give the answer. I am not giving you the answer, right? Safely I am saying, he is the government, and there can be nobody above the government, right? And he is head of the state because the democratic republic, that is the only clue directly available, right? So in that sense, you tell them the reality of life, that if you want to become a civil servant or a judicial officer, this is the way, right? Otherwise, as a student, as a teacher, as a researcher, you need to think beyond, and you have to tell, write and tell. That is why pen is mightier than the sword. Tell the judges you are wrong. In America, the Harvard Law Journal, the moment it is released, the first set of people who would read are the 9 sitting judges of the Supreme Court. Why? Because their judgment is critiqued, not criticized. Critiqued with reason, and the judges feel that their reasoning is weaker than the reasoning given in that article by researchers, professors, teachers, and others. They look for an opportunity the following year to change their opinion, right? Number 1, in India we don't have such a journal. Number 2, even if you have a journal of that nature, the judges have lost their reading habit long ago. Nobody will read. Only the clerk will read and say, right, it is given. So we can't expect any change, right? This will.
So judgments are very thick, right? So many pages.
Yeah. Yeah, that is why
Somebody must be reading and writing.
Yeah. See what happens is, I don't know how many of you interacted with the judges. I have, I know half of these judges of the Supreme Court, and many of the judges in various high courts. So some of them are my students also, right? I know very well that fellow cannot even speak properly. He writes a very lengthy judgment, right? The language is so superb. You feel, okay, this guy is really good, but he has not written, he has only signed. Right? The clerks are there, they will assemble all the material, and even without reading, they sign. And I will just give you 2 examples. The Delhi High Court, 3 judges, full court, it is called as full court, High Court, delivered a judgment on IP law, intellectual property. That was the case, right? They delivered a unanimous judgment. And once the judgment is delivered, the bench becomes functus officio. I hope you understand what is meant by functus officio. Do you? Once the judgment is delivered, the bench is constituted by the Chief Justice. And their job is only to decide that particular case. Once they sign, seal and deliver the judgment, the bench becomes functus officio. Till they are assigned the next day the Chief Justice may give some other work, right? Some other case. They become functus, they cannot come and sit together again, right? 3 days passed by. They went to different benches, right? 3 days after, Hindustan Times of India carried in the first page that 59 paragraphs in the judgment were copied from a book. Without 59 pages and paragraphs were copied literally from a book which the judges have not acknowledged. and the judgment is on intellectual property. Right? The moment they saw this newspaper clipping, they all went back to the High Court, reassembled as a bench once again, recalled that order. Say, oh, do they have a jurisdiction? In my opinion, they don't have a jurisdiction. Someone can appeal, right? And the Chief Justice may constitute the same bench, right? And then they may remove it. I met some of those three judges. I asked them, sir, how is it that we can? We have implied power. We have implied power, so I can do anything I want. So they removed 59 paragraphs, and finally, that is very interesting, the researcher has committed a blunder. I think Yogesh is also there. He has also done the work as a researcher in the Supreme Court. Right, 59 paragraphs we are removing. It is a work done by the research officer. We are not responsible. So they have shifted the burden. Right? And after removing that, they signed and then, right? Do you think that they have the authority to do it? Within a week, it so happened, it's a disease, I think. Madras High Court, a division bench, decided the case on right to information. They also referred to some book, 14 paragraphs they copied. And again in the newspaper it came. And again they went and constituted themselves as the division bench. Withdrew that, blamed the researcher. Right? These are all things that are happening. You have to bring it to the notice. Therefore, you inculcate, don't limit yourself to ChatGPT. ChatGPT can serve some purpose, not everything. Think of your own, write on your own. Yes.
I will share one story.
Yes. We want more stories.
In Supreme Court 3 years, Chief Justice of India, he wanted some information on how to balance various fundamental rights. So if there is a clash between Article 21 or Article 19, then we should prevail. So we did a research and we provided, and we expressly mentioned in the file which we gave and not to be cited. This is the research. We gave citation also. Yes, we have taken this thing from this website or this article in journal. But after 5-6 days, we found the judgment was delivered and it was copied entire and without any citation. So this is happening in the office of the Chief Justice of India.
Because they have not read the first one, not to be cited. Right? So therefore, we are even after 75 years, we don't have the courage to tell the Supreme Court that they are wrong. We are not willing to tell the High Court that he or she is wrong. And that can be done only through your research. Right? And I think if at all you want to carry some homework, an advisory opinion is given, right? 111 pages. Please read, and if you can articulate your opinion and write to the Supreme Court that where they have gone wrong, right? Possibly, I think there is already some lawyer who has written, right? So therefore, we have the freedom of expression, right? 1918. Please exercise, right? For us as teachers and students of law, it involves research work, and we have to inculcate that research culture, right? So interdisciplinary research, for example, today you have the digital databases, right? Electronic evidence, how to appreciate it. The district judge doesn't know about computer, doesn't know the spelling for computer, right? How do you think that he will understand the evidence value? The Evidence Act has been amended. How are you going to, therefore, you have to bring all this culture into the knowledge, right? So I think we will not go beyond this. Second question is also satisfied. The third question, right? I think Yogesh also replied, he knows the answer. I'll ask him to keep quiet. Right? What is meant by President's Act? What is your ChatGPT saying? President's Act. And yesterday I gave you in the PPT this year, I have given different tools of AI. And if you do the same question, you will not get the same answer.
Yes, sir, different.
Limited, right? Otherwise, you will not mention that. So there are a number of them, but you don't get the same message, right? So what is Google Power saying?
President X also known as President's Rule.
President's rule.
Provision under Article 356 of Indian Constitution.
Okay. Anything else?
That's the problem of it.
Recommendation of the governor.
Now,
Post.
This
Approved by the process
case
of
of
parliament.
political crisis, internal subversions or physical breakdown and non-compliance with constitution.
right, it doesn't give us any idea as to what is meant by President's Act. Right? Now, Indian Constitution is little strange. Even the powers that the Crown in England does not exercise, the power is given to the President under the Constitution. Whenever the President invokes Article 356 or the advice of the Council of Ministers, I think in clause 2, the President transfers the legislative power of the state legislature to the Parliament. Right? Now go back to Article 72. I'm sorry, Article 53. The executive power of the Union shall be vested with whom? With the President, who shall either discharge it directly or through officers subordinate. Parliament is not officers subordinate. So he has shifted the legislative power of the state once that Article 356 is invoked to the Parliament. Then 357, this is constitutional authorization of delegated legislation. Right? The Parliament can make the law for a particular state. Now, if Tripura is dissolved, state legislature is dissolved, the Parliament will make a law, right, saying that we are going to make a law, and then authorize the President. And see the beauty, and I don't want to convert this into a constitutional clause. In 357 it says, the Parliament will make a law first, through the law it will authorize the President or officers subordinate to him, up to what level it can go, can make the law for the state of Tripura. And this law is called as President's Act. It is not made by the Parliament. When the Parliament authorizes the President and other subordinate officers in making that law is called as President's Act. Right? Now you change your question and ask ChatGPT, can you list the President's Act?
It says no constitutional law called President's Act.
That's even more good.
The very official law is President's Rule.
So it is totally misleading. It's going in the opposite direction. Right? We know President's rule.
President's emoluments and pension at 19.
So you will get everything except this.
President Discharge of Function Act of 1960 and President's Rule.
There are more than 300 pieces of legislation. I think in the law school we have done some survey. I used to give this as a project to the students. They have listed, in those days, 80, 90, 200. I think today there are more than 300 pieces of legislation under the title President's Act. Right? So, when your ChatGPT is not giving the right information, why do you rely upon this? Right? So, I'm not saying don't use it. I'm saying please use it so that we can tell them that the information is wrong. Right? And therefore, what is the objectivity in this? Or what is the central purpose of this? The central purpose of this is how to engage the students in a classroom discussion. When they are not willing to listen to you even for 20 minutes, right? They take their mobile phone and play some game or send messages, right? How to utilize their time, focus on a particular theme, get them involved in that. I think if you do this, the attention span will go from 20 to 25 minutes, 30 minutes, and then the next is setting the question paper. Right? Before I start that question paper setting, we had a professor called Professor Devidas. Right? He was also a student of Professor Devidas. I think I would rate him far better than Upeda Bakshi. He did not have that opportunity to go out, right? But I think he is a great teacher, right? He is 93-year-old, he is still in high school. And the students wanted to have open book exam. He agreed, he was teaching to the students, he agreed. And then the examination was conducted in the library. I was the chairman of the Academic Council. So we prepared the question paper and the instruction given in the, what you see the instructions, like this. They can take their class notes, they can refer to any book in the library, right? And the examination was for 3 hours, right? So distributed the paper, the students were all very happy. Because it's no one took examination. They took all their notes, right? And then 30 minutes, first the girl ran. I just went down to find out how much they have completed. Almost 95% of the students have not even completed the first page. Half an hour passed by, they could not complete one sheet. Again, after half an hour, the supervisor, please later, they came, sir, they wanted to speak to you, so I went there. They said, this paper cannot be done in 3 hours time. We need more time. Right? Can you change this, extend the time to 1 hour extra? I said, I will do it, provided the teacher accepts this. So I went to Devidas and asked him, stupid fellows. That was his response, stupid fellows. If they know the answer, 1.5 hours is more than sufficient. So I came and told them, you have to finish. Then they started all the, they did not go to the libraries, staff to pull the jurisprudence book. They were churning their class notes, right? It was wonderful to see them in such a fix, right? And then they came out, and the unanimous resolution of the class was, we don't want to open the book. Right? That is the severity in which we have to look at. You ask them to use ChatGPT, no, nothing. No, if they give answers like this, there is no president's right, there is only president's rule. Zero.
No, so it's very smart. I say I'm highly disappointed with the answer. He says, there is I understand your situation, but I have mistaken that it's a rule to be corrected. So then he gave me another withdrawal act references and all. So I'm surprised it amends and corrects it.
Yeah. So
it's an act of parliament with presidential assent.
No, every act that passes by the parliament is with assent. Again, you say it is wrong, and the ChatGPT will say, are you a human being? Right? So these are all issues, so we need to look at, if you don't use technology, let me tell you, the students will pick you up. Gone are the days we enforced, yesterday I think I told you, mobile phone, don't bring it to the class. Today, that is the order of the day in the US. In the schools, they say you cannot bring your mobile phone into the classroom. One state passed a law saying you cannot even bring the mobile phone to the school. Right? If you bring it because you are coming from distant area, keep it in the locker. That's the only concession they can give. Things are changing because, and I told you, Australia, many of the European states and some of the states in the US, they are back to pen and paper examinations.
Yes.
Right? Not your digital. Yes.
I was practically that it was allowed because so I told them that you can use the ChatGPT But I will not assess you, evaluate you based on the presentation that you are making, the discussion you are making. Please send me the summary of it. So then everybody is giving me the prompts. So the best of the prompts were actually awarded the mark because the person who understood good, you will write the exact prompt rather than uploading the case directly and writing give me analysis, give me a summary, provide me the answer to these questions. So those are absolutely 0 mark.
Right? So open book is a process where it gives lots of confidence to the students, right? But you trap them once or twice like this, they understand you better, they start focusing in the class, right? What is being said, because we should know what to look at it, right? For good students better, you don't look into constitutional law, right? So you should know where to find the law, where to find the answers, and how to translate that into a paper, right? So you can tell them to use their job. So if you make anything wrong, the only advantage is the student will be with you. Today it is an art of winning over the students, right? And once you win over the students, you are the most popular teacher, right? And I think even the Vice-Chancellor should understand, right? I think Yogesh will understand, right? Allowing the students to use ChatGPT, right? Okay. Now, how will you frame the question paper? Right? I have seen in my last 40 years plus, right? The traditional universities will send last 10 years question paper. You will sit in the bus, 10 questions from 10 years, over, all explain, briefly provide this, do this, do that, nothing more. Right? But whereas, in the law school examination, particularly when you have to give case studies, right, you have to modify your answer. I gave you the example of this advisory opinion. Before that, there was a judgment delivered by a division bench. Governor of Tamil Nadu versus State of Tamil Nadu. Both of them went on an appeal to the Supreme Court. The division bench, right? So, what do we expect from the students? Originality, thinking with it is not reflected in the judgment, but they are able to say something different. So, always in the question paper, we also indicate that any independent view expressed will be given due weightage. We don't say how much due weightage, right? Now, if this judgment is questioned, how would you write? Right? Everyone, the judges are wrong, fine. One student possibly will write, that will be me, or another student, Yogesh, right? I want you to carefully read Article 145, Clause 3. Article 145, Clause 3.
The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law.
Involving substantial question of law.
As to the interpretation of this constitution or for the purpose of hearing any reference under Article 143 shall be 5.
How many judges are required?
5.
Minimum of 5.
Minimum of 5. Was the Chief Justice stupid fellow to appoint only 2 judges to decide this case? Is this a case which requires interpretation of law as to the interpretation of the Constitution? What did they say? That if the government does not give his assent within 90 days or 3 months, it must be taken as deemed assent. Right? So I was also very angry when I read it. Right? Luckily I don't practice. If I go to the Supreme Court before the same bench and say my client is Yogesh, right? The case is now presented to the court. If you don't decide within 3 months, it is deemed a judgment in favor of my client Yogesh. Where will they go? 35 years, 40 years, the cases are pending. They don't have sense of shame. the Chief Justice did not understand the constituted division bench of a constitutionally important decision. Right? And Article 145 Clause 3, in my opinion, is a basic necessity to be applied to the court. And if they don't do it, for me, the division bench judgment is not what the paper on which it is printed. Right? So if some student writes this, I will give him full mark. One more instance I will tell you. I will come back to this. Professor Mitra, right, is such a senior person. We also give the model answer. So what I am trying to say is, it is not only question paper, but you have to give simultaneously model answer. As you teach, if you think it is a potential case to be discussed in the examination, go back and write it in your, at least in your laptop, and take that problem with you. So that you don't have to search for questions when you have to set the paper. You set the paper, and by the time the students complete the exam, at 5 o'clock, if it is over, 5 o'clock the library will have 10 copies of the model answer. The students will rush to the library to see the model answer, and they will evaluate where to stand. The paper was set by Professor Mitra, valued by Professor Mitra, and the papers were distributed back in the class. And he made one beautiful observation. Still, I can't forget it. He said, I am withdrawing my model answer. I am withdrawing my model answer. But the model answer written by a student, I think he also knows Umakant.
Yes.
Right? Is far better than my model answer. So I am replacing my model answer with the answer given by the student. Which teacher will have the courage and conviction to say this? By saying this, as it becomes smaller? No. No, certainly not. So therefore, creating the question paper, the first thing that the teacher should do is, when you engage in the class, a particular issue arises, you go back and pen it down, or keep it in whatever form you have, right? And say, this is the question that we would like to pose. Right? Our idea is there. It becomes easier because the answer is also there in the same. Right? Whatever you discuss, the answer is also there with you. So when you frame the question paper, first thing that you should do is, you also create a model answer. Key. It is not that you have to write full answer. In telegraphic language or bullet points, these are the things that are required. Right? And anything independent and above this, the students will get a due credit. Please put that also in your question paper. So that we can expect some originality coming from the student, and that is a constant process of teaching and learning. And I delivered a lecture 2 years ago, there Justice Desai Memorial Lecture. My first paragraph was thanking the students of law school, right from 1988 till I left the law school, because they made us work. They raised number of questions based on which we went through the Constitution. We went through the judgments, right? And I thank them, because what I am today is based on their continuous questioning and support, and also some of my colleagues, right? So therefore, you have to think about the circumstance, the situation. Something, always law is not static, it is keep on changing. So that judgment came, Vice-Chancellor the advisory opinion has come, they have to be in a position to understand all these things, right? And then what type of questions you should ask. Please do not ask the essay type questions. Describe how the president is elected. What are you going to name? Right? But if you don't include, a large number of students will also fail. I hope you appreciate what I'm saying. See, don't mistake me, I'm saying do this and don't do this simultaneously. Right? You have to understand the class first. Right? If the class, if it is a master level class, right from the beginning, I say every question will be problem based, the students understand. At the undergraduate level, it is little dicey, little tricky. Right? So you have to give some, explain this, briefly narrate this, do this. Right? So therefore, very quickly, if I just take you, this is the question paper I set some time back. It is not. Whereas in the traditional universities, they give 10 questions, you answer 6 of them. Right? Or 7 of them. So, first instruction is answer all questions. Do you have the courage to do it?
The exam department doesn't allow sometimes.
Right? It's a challenge. In law school, it is not a challenge. In traditional universities, it may be a challenge because the controller doesn't understand. The Vice-Chancellor will not like to do anything. But in law schools, it may be possible. So it is undergraduate course. Right? Answer all questions. Not even a single student raised objection in the last, say, 30 years of its existence. Right? Number 2. Candidates are permitted to take the bad text of the Indian Constitution without any marking. Right? The case allegation, some notes are given. Right? We used to get the Government of India publication and do it at the time of examination. It gives them confidence. You don't rely upon your damn memory. Right? If you have the text, half of the burden is gone. They think they can refer to the text, but they should know where to look for. Right? So the text is not bad. It is not bad text. Constitution is always called as bad text. It is not an act passed by the Parliament. Right? Though some of the private printers, they call it as bad act of the Constitution. Right? It is the bad text. We use the term bad text. Even in dream, we don't say bad act of the Constitution. Right? So, if you are teaching contract, you say the contract act is permitted. Like Professor Devidas, you can carry your class notes. Nothing wrong in it. Provided the content of the question paper is little distinct, which they cannot simply rely on copy. Then you can allow them to carry anything. It gives them confidence. Okay, I can do something. Right? Okay. Third one. Refer to the relevant provisions of the Constitution of India, statutes, and judicial decisions wherever required. I am not going to say what the court said in each and every case. It is a general command. Wherever it is required, you please mention this. Right? What is it? The appropriate provision, relevant provision of the Constitution, the statutes. If I am discussing about the judges' removal, then the Judges Inquiry Act, Judges Inquiry Rules, and the 3 decisions, the removal process of the other judges. All these things are the judicial decisions, everything they are supposed to mention. Right? And the last one, no clarification can be sought. If there is a mistake, the student will come and say, there is a mistake in the question paper, we give full credit. Right? So you understand, the psychology of the student revolves around these instructions. First one, no choice, finish. Right? Then they have an open book and they are confident, okay, at least I am able to carry the text. In every contract act, property, whatever it is, the act, the relevant act, family law, the relevant acts. Every time, you see the examination of filled with statutes, it is distributed and collected back. Can we do it? If you do it, your examination system will be transparent, entirely different. Your job, is only not to ensure or to ensure that I don't copy from her, right? And that is the only thing that I have to do. Otherwise, they are busy in writing, right? Okay. Now I am giving examples because in the undergraduate course, if I say all of them will be problem based, in the postgraduate course I can do it. But I think today even postgraduate courses, they require more descriptive questions than the undergraduate students because they come from different law schools or different universities where these things are not part of the culture. So I'll just show you some of the, right? Now I have taken a comment from Munshi, I'm not going to read it out, right? And then say, what made Dr. Munshi to change his views subsequently from the views expressed by him during the Constituent Assembly debate? 4 marks. You don't write essays, right? The student should know what Dr. Munshi mentioned in the Constituent Assembly. what changed in his later publications, right? Very crisp answers, even if they write in one page. These facts then 4 marks are given, right? Second one, briefly explain. See the difference between the first question and the second question. Briefly explain and critically evaluate the special leave jurisdiction of the Supreme Court of India with the dissenting cases. Right? When compared to the first one, the critical thinking record is minimum. There should no special, leave petition under which article it comes, 1 or 2 judgments, if you know, it's a broad memory, whatever they know, even without referring to the text, they can write. So there is a difference between the first question and the second question. Now the third example, right? The third example is a problem, right? Yeah, please. A sitting member of the Legislative Assembly, along with 4 other individuals, B, C, D, and B, I don't mention the name, but you can put the names also if you want, and went to the industrial estate and murdered X in the broad daylight. D, though was armed, did not cause any injury on X. D was one among the accomplices, but though he had the weapon, he did not cause any injury to X. X was removed to the nearby hospital and was given best of the treatment possible, but died the same evening on 23/2003. So this paper I taken from 2003. Right? I did not prepare for this presentation. It was a ready-made paper, so I got it. Right? A had 5 separate serious criminal cases pending in various courts in the state and has been delaying the judicial process by giving some reason or other to his lawyers. The police arrested all of them. See, this is based on a judgment of the Supreme Court. I only changed the name, right? But I am elaborate on the facts, right? And then say, many criminal cases are pending. They arrested everyone. The sentence judge sentenced all of them to life imprisonment, except D, who was sentenced to 7 years imprisonment for the offences committed by them, both jointly and severally. On 30/11/2009, because it's a murder case and then life imprisonment, right? The High Court also confirmed his sentence. Between 21/3/2003 and 2009, the date, A was under custody for only a week. This is the time bomb. This is the trial, right? In the war zone, they have called it as mines, right? If you step on that, boom, it goes. So this is a trap. The trap is, see, I'm narrating everything, but silently I have introduced one sentence saying A was under custody for only a week and was allowed to enjoy the privileges as a member of the Legislative Assembly. Right? He was an elected MLA. Right? 5 criminal cases are pending. The more cases are pending, you are eligible to become a member.
Yes, sir.
Right? So, enjoy the privileges as a member of the Legislative Assembly by the prison authorities, while the remaining 4 were in custody. So, you have a special treatment, right? Because you are sitting MLA. If you are a minister, even more better facilities. Convert the prison into 5-star hotel. All these things are possible, right? Then the election takes place. I don't want to read the full text. The election takes place. I remember the case, right? And because he was already convicted of an offence, he could not contest the election. And what is the solution in India? If I cannot contest, Lalu Prasad made his wife to contest. She got elected, and the party comes back to power, right? And through his wife, the process, the file goes on, and then the Council of Ministers recommend that he is such a wonderful soul. And see, there is one more time, mine somewhere I have left. Right, mercy petition, that's over. Right. 2 time bombs. One is, if you read, They even went to the extent of certifying good conduct while in prison. Who certified? The prison authorities. How long was he there in the prison? 1 week, enjoying the facility. That is the good conduct for them. Now you understand that the ministers, how much influence that they have in the bureaucracy. Right? Second, somewhere, I also mentioned you have to read the full case. I will also read this if you want. I have no issue, no copyright. He gets admitted into a private hospital. Right? Maybe the hospital belongs to him or his relative, we don't know. Right? The hospital, after 1 week, he gets discharged. Now, how people think and use law? The mercy petition goes from her on humanitarian consideration. He is not keeping well. Therefore, on humanitarian considerations, he may be pardoned. Right? The first pardon was rejected by the governor. Right? Second time, within 2 years, the same stupid governor, right? Now the recommendation goes from the chief minister that he may be pardoned on humanitarian grounds. The governor pardons him. Right? These are all facts based on a decision of the Supreme Court. You should know the judgment, and it is not simply one judgment. We also had, the minds or the time bomb somewhere. You should carefully read them and then come to some conclusion. So that, when you go and supervise the exam hall, the students keep on underlining the important phrases which they should not forget. So you make them more attentive in the examination hall. Not simply, first question, it says briefly explain. Right? About the president, whatever he or she knows, they will write. Whatever you don't want, still they write. Right? So therefore, after writing all these things, the governor pardons that MLA who was a murderer in the broad daylight. Now I have given all the facts on humanitarian grounds. Right? Now the problem begins. The widow of the deceased moved the High Court challenging the order of the governor. Right? How can we pardon him? Right? The widow of the deceased. Now there are 4 different questions which follow. Now they have to marshal the facts of the case. That is the first. A law student must marshal the facts. He should know or she should know the facts thoroughly. They should know the law thoroughly. They should know the relevant judicial decisions thoroughly. Right? Then only they can articulate the way they want. Right? Prosecution will argue in one side. The defense also will argue on the other side. Both are arguing on the same issue, same facts, same law, same judgment, but different views. And that is the beauty of law. Right? Now, the first question, if you are representing the widow, on what grounds can you challenge the order of the government? Right? Now, if you go to the previous questions, descriptive questions, it is one-way traffic. You can write anything you want, and sometimes they write the same questions 6 times and they get asked mark, and they ask for re-evaluation. Now that he has the guts to ask, and then in re-evaluation he may get second clause also. But see, if you are representing the widow as a petitioner, right, on what grounds can you challenge the order of the government? So, as I mentioned, you have to understand everything, the fact, the law, the judgments, right? And any new, if you are of that mind, right? He was in the broad daylight, so there can be no humanitarian consideration. Something not based on law, but based on facts. Right? And number 2, he was never in the prison, he was there only for 1 week. The good behavior given by the jail staff is totally illegal and cannot be relied on. Which the judgment doesn't say. But the student is able to articulate those facts. Right? That's why I said they have to read the facts. And to flip this question, not from one judgment, but you take from couple of judgments, tweak the loyalty, tweak the judgmentality, enhance the size of the bench. If it was a division bench, you say constitution bench. Right? If it is High Court, you say it is Supreme Court. I think you have a number of permutations and combinations in the question. Right? You write it. Second question. Right? See the second question. If you are representing the state government, right? On what grounds can you defend the action of the government? Completely opposite. The student just now completes on behalf of petitioner. Now you ask them to write on behalf of the second party. Opposite. Completely opposite. And that is the place where they are able to think and balance. Right? So a lawyer can go anywhere. It can be a lawyer representing the petitioner or the prosecution side. You may go anywhere. But you should have the conviction, courage, and the knowledge required for you to defend the case. So they also write. Right? Whatever defense they have, they will also write. Something imaginative which just try to explain. Right? Give additional mark. Third one. If you are a judge of the High Court, I will not dissent. Right? Not like what Yogesh said, a copy from book, write the judgment. Right? So therefore, if you are a judge, the job is much more and entirely different from the first two. But you will rely on the material given by the petitioner, the material given by the respondent, which you are. You are the only person. You are appearing for both of them. Now you are writing a judgment. Your thinking will be entirely different. It is the same law, same judgment, same fact situation. Your mind is applied in 3 different directions. Right? And that is not the end of it. The fourth question says, if you are a researcher for the Law Commission of India on this issue, right? What recommendations will you advance? Give reasons. We don't give any reason. Even in the model answer, we don't give. But we evaluate something distinct. They will get full weightage. And for all these things, what is the mark given? 8 marks, 2 marks each. You don't write essays. We don't want you to write essays. Based on all these things, you just write precisely argument number 1, 2, 3, 4 and 5, finished. Defense, 1, 2, 3, 4, finished. Judgment in, maybe one paragraph, repeating some of them in what you said in 1 and 2. And finally, as a law researcher, you are bringing some new facts, right? For example, why should the governor be bound by the advice of the Council of Ministers? Right? Something you raise a question, right? So therefore, in such cases, there is another case which we read, Ipur Sugakar, that's the state of Andhra Pradesh, where it was argued on behalf of the prosecution that he was a wonderful Congress worker. But no, he has suspected somebody, and the defense is he is a wonderful Congress worker, and therefore he must be, pardoned. What nonsense is this? Right? So you are able to call out all those decisions on the power to pardon and write this. Right? Very precise? Okay. Right? There are other problems also on parliamentary privileges. Election of the president. Right? If election of the president, if somebody asks me to teach, I will teach at least for 8 to 10 hours. There is so much of material that is required that we don't know. If you refer to any book, they refer to Article 54, 55. This is how the president is elected finished. We don't know anything else. Right? So therefore, if you see, this is about the presidential election. I give lots of, to prepare the question paper, we spend lots of time. You got the point? And once you do it, as you do it, you also jot down the answers, key answers. Your job is simultaneously done. And if you are able to do that, as I mentioned to you, please keep in mind, when you complete the class, right? Whenever you find the 2 minutes, 3 minutes, jot down. This is the question that you would like to pose, because we have discussed that in detail in the classroom, beyond the books, beyond the judicial decisions, right? So therefore, after 2 days you will forget it. But you jot down, then possibly it is much more easier for you to narrate it and create a sort of question bank, because it is required for the midterm exam, required for the end term examination, required for the repeat examination. And next semester, next year, say another batch comes in, you cannot repeat the same question. Right? So keep on adding to your question bank. Possibly you will have a folder, which I think you will also learn from the mistakes that you commit and then keep on refining. I think that will give you lots of solace, right? And the students also will appreciate the way that you can read questions. Last but not the least, I have mentioned in the PPT that is shared with you something called as coupling. This is 2003. 2025, I have to ask the question, midterm, 30 marks questions, right? I rely upon this gaming platform called as Kahoot. I mentioned to you, beautiful, wonderful tool it is, right? I will administer the question, let the student sit there, use the mobile phone, right? But they have to respond to that question within 30 seconds, 40 seconds, 60 seconds, whatever time you fix, right? And they cannot copy from each other. That is what you are supposed to ensure. I think sitting and reading it is not your concern, because you have done that in the formulation of the question itself. Right? The right answer, the reasons for the right answer paragraph. Right? So if you just test them, even two term tests you have, 10 marks each. Right? Half a mark objective type questions. They will also enjoy. Your burden to sit and evaluate will also come down. Your arbitrary evaluation will go, right? And then what you do is simply press the button, take a printout, sign and give it to the exam. Yes.
Sir, I have a doubt if you can help me understand. We have a multi-campus coordination meeting in which the same subject which is taught in different campuses, Chandigarh, Bangalore, Bombay, all these places. So those teaching, those faculty, those are teaching come together in March and check whether syllabus and preparation of question paper. Sometimes it becomes very difficult to convince the faculty, other faculty, because we have a portion to know how to frame those question papers. So it is very rigid. Time to go beyond the.
No, if the syllabus is given, the job of the teacher wherever they are, they have to teach the same thing. Maybe the method of teaching may be different, but if the question is the same, I think the student must be in a position to respond. I don't see, now you take any of the competitive examinations, but the syllabus is given LLM or undergraduate. These are the areas on which we are finished. Next, this is not a big issue. Right? Any questions? So I have given you both the past and the present and future. If you want to be the good books of the students, which you should be, not by giving marks, but by using technology. NEP is also now threatening all the teachers must have the capabilities of using AI tools in the classroom. Right? And that will take you to the next level. And possibly I think law schools will also learn. Now the problem is, yesterday I told you, who is a good teacher, right? Teacher who transmits the information from the book to the students without either of them understanding. Now you should not become such a stupid teacher, right? Make them think, make them work, you also learn. I think the benefit is, you constantly learn. If you think that I learned everything, the teacher dies then. Right? Not physically, but the ability to learn is key. I think with all this mixture and different components, your own experiences, I think you can do a better job than what you're doing. Right? I'll stop here. If you don't have any questions.